Hello and welcome to this session. In this session, we will discuss how the law regulates board of directors by requiring them to act in the best interests of corporation law. So does this mean only shareholders, or can boards act in the interest of customers, employees and suppliers? So my name is Firas Salan and I'm the faculty liaison manager for the Sydney Law School and the Sydney School of Architecture, Design and Planning. So today we have with us Professor Jason Harris, who will be presenting on the purpose of the corporation. So Jason joined the University of Sydney Law School in 2019 as Professor of Corporate Law. Jason teaches and researches in the areas of corporate law, insolvency law, commercial law, and contracts. Jason's research is focused on the public and private regulation of financially distressed companies, including debt restructuring, voluntary administration, corporate governance, and directors' duties during financial distress and the regulation of corporate groups. So a bit of housekeeping issues, we have the Q&A functionality, as you can see at the bottom of your screen. So please, and I would really encourage you to use that functionality and not use the chat box. So Q&A will be monitored, and that would make it easy for us to respond to your questions. So towards the end, we will endeavor to answer all your questions. So probably in the last 10 to 15 minutes, we'll have some time to respond to your questions. And now over to Professor Jason Harris.
Thanks very much, Ferris, and thanks everyone for giving up your time today. What I'm going to talk to you about today is a section of a lecture that I give in one of the compulsory subjects in the JD program in the law school, and that's the subject corporations law. So this is a subject that pretty much every law student in Australia has to do. It's also a subject that students who do accounting degrees have to do. So it's a pretty important area of the law, whether you intend to work as a lawyer or if it's just relevant for your business. One of the things that I say to my students at the start of the corporate law course is that students often come to corporations law with some preconceived ideas of what corporate law is. And often in the mainstream media, we hear the term corporate law, the corporate approach, these sorts of things in a slightly pejorative way. And like I like to remind my students, corporations are all pervasive in society. Virtually everything we do every day is touched by a corporation, whether it be the transport company that takes you to and from work or the university, the corporation that possibly owns the accommodation that you're staying in, the corporation that provided you the food that you got from the supermarket, the corporation that you get your finance from, the corporation that you work for. Corporations do almost everything for us in society. And we need to recognize that corporate law is not just about the kind of big commercial enterprises that we hear about in the news and we read about in the paper, the Qantases and the BHPs of the world. Charities can be corporations. Hospitals can be corporations. Universities are corporations. So when we go through the subject corporations law, yes, we do have a lot of examples that are drawn from so-called big business, but corporate law is certainly not limited to that. Corporate law is a huge area of Australian law. I've actually got a copy of the Corporations Act here. It's a huge piece of legislation, and it covers so many things that we do both in our personal and our working lives. And the topic that I've chosen for you today, which as I say is part of one of the lectures that I give during semester, really is at the core of that. And that is, how does the law regulate the management of corporations, not just the management of business corporations, but the management of all corporations? How does the law regulate the management of those corporations? And really it's posing the question, why do we have corporations? And what does the law have to do with that particular question? This is incredibly topical. It's always topical. I've given this talk several times over the years, and this topic is always very topical because corporations are pervasive in society. So there's always some big story about what a company is doing or not doing, or perhaps calls for companies to be doing more. Many years ago, some of you might recall, this used to be called corporate social responsibility. These days we tend to talk more about stakeholder capitalism. And these are issues that we really look at throughout the corporations law compulsory subject in the JD degree. But the angle that we're going to focus on today is really looking at the role of directors' duties. So there are provisions in the Corporations Act, as well as some general legal principles that tell us what company directors are obliged to do, in whose interests should they be managing the corporation. That's really the question that we're going to work through today. Now, if you do have any questions as we go, or any comments, please do use the Q&A function, and we'll get to those at the end of the discussion. Okay, so let's start with the popular concept of shareholder primacy. Now, as you'll see as we go through this discussion, shareholder primacy isn't really a legal concept. It's more a theoretical construct. And it's the idea that the directors should be exercising their powers in managing the company, in running the company, in supervising what it is that the executive managers are doing, that they should be exercising those powers ultimately for the benefit of shareholders. And one of the things that we do in the corporations law subject is we get students thinking about what a corporation is, why corporations exist. Are they only set up to provide economic benefits to their shareholders? Or are they set up for other purposes? And of course, the answer is a bit of both. When we're talking about small companies, family companies, kind of joint venture, quasi-partnership type companies, we might say that really they're just established to provide some form of economic or other benefit to the owners, the people that establish the company. But when we're talking about larger public companies like the major banks, Qantas, BHP, the question is slightly different. And one of the reasons the question is slightly different is because when we focus on large publicly listed companies, the question of who are the shareholders is different almost every second, because these big public companies, people are buying and selling shares all the time. So the concept of the directors needing to consider the interests of shareholders is a difficult one if we take that to mean the actual shareholders. In large publicly listed companies, the shareholder base is changing all the time. And all of those thousands, if not tens of thousands, potentially millions of shareholders might have very different views about what conduct will be in their best interest. So what you'll see as we go through this discussion is that the law creates this idea of the hypothetical shareholder. It's not the actual shareholders that we need to be thinking about, because the actual shareholders will rarely agree as to what's in their collective best interest. But it's the concept of a hypothetical shareholder. And we're going to dig into that concept a little bit. And what we'll see is that, at least this is what I'm arguing in this discussion, is that by creating the so-called hypothetical shareholder, we're actually giving boards and management tremendous flexibility to act in the interest of the corporation itself, not merely in the interest of individual shareholders. But this is a very long-running debate. So you'll see the reference there on the slide that the classic debate about shareholder primacy versus directors being some form of custodians or stewards or trustees for the benefit of the company goes all the way back to the 1930s. And the debate between two, at that stage, quite famous law professors in America, Adolph Burley and Merrick Dodd. And through a series of articles in the 1930s, they were debating how corporate law should regulate the conduct of corporate boards, and really trying to pose the question of in whose interests the board should be considering when they're exercising their powers. Burley's view which came out of research that he did looking at the ownership of public corporations in America at the time. Burley's view was very much influenced by a concern that managerialism within companies would mean that boards would become effectively unaccountable. And so Burley was concerned about aligning the interests of shareholders with the focus of directors' duties. It was essentially an accountability mechanism. How can we make sure that directors are doing the right thing, that corporate managers are doing the right thing? If we tie it to ultimate shareholder benefit, it gives us an accountability measure that we can assess their conduct against. Dodd, on the other hand, had a very different view. He saw boards of directors more acting like trustees, and they were there not merely to promote the economic benefit to shareholders, but to benefit society in general. And this is one of the early forms of corporate social responsibility. It's interesting that decades later, on his retirement, Burley actually conceded that Dodd had probably won that debate in the long run. The contrast we see between these two perspectives might be said to boil down to contractarian perspectives drawing on law and economics, the idea that a corporation is nothing more than a nexus, a facility through which the owners of capital, shareholders, negotiate with the managers of that capital, the directors and the executives who work under them. So that's very much an economic perspective. It's an instrumental view of what a corporation is. It's there to facilitate the collection and management of capital. We can contrast that with stakeholder perspectives. And this is very much where we're focused on the debate at the moment in Australia. And we'll come to that in a second. But it's the idea that the corporation is more than just inputs of capital. The corporation is an entity in society. And when you do corporate law, you'll see that one of the first provisions in the Corporations Act actually sets out that a company is to be treated as if it were a natural person, that it has the same rights and powers pretty much as a natural person has. Company can't get married, company can't go to jail, but most things that real people can do, companies can do as well. So the contrast to the economic perspective is that boards should recognise that companies affect different stakeholders, employees, customers, suppliers, local community, government, creditors, in addition to shareholders. And so therefore boards, as responsible overseers of the company's conduct, should be thinking about how the company interacts with those different stakeholders. So these are contested visions about what a company is, about whose interests it should serve. Is a company really just a facility to extract value from private property? That's the economic perspective. Or is a company more a quasi or indeed fully public institution? It's a social actor in society. Is it a real thing recognized by law, given legal powers and legal consequence for what it does? Or is it merely just a legal facility that's set up to reduce transaction costs? And at the heart of this is this question of, are shareholders the bearers of the residual risk? You know, at the moment, we're talking a lot about the harmful effects of the virus. And the predictions are that we will have a significant increase in corporate insolvencies and a significant increase in personal bankruptcy. And corporate law then poses the question, when we're assessing the role of directors, as to should they only be considering the ultimate long-term interests of shareholders? And the economic view of corporate law would suggest that shareholders are the bearers of residual risk. And this is the idea that how do shareholders make money by buying shares in a company and holding those shares? They can make money by selling shares at a higher value than what they bought them, okay, capital gains. They can make money by earning dividends on those shares. If a company makes a profit, it then decides to set aside a certain portion of that profit and pay that as a dividend to its shareholders, to its investors. So under the Corporations Act, it says basically companies can't pay dividends unless they're making some form of profit. Now, there's lots of rules, and particularly accounting rules, about how we assess that profit. But if a company's making a profit, then it must mean that it's paid all of its debts that were already due. So it's paid its taxes, paid its utilities bills, it's paid its employees, paid its suppliers. And so at the end of paying all of those fixed costs, there's a surplus portion of money that's left over, and that's what gets used to pay a dividend. Now, again, the reality is a little bit more complex than that, but that's the rough idea. So on this view, shareholders are the bearers of the residual risk, because if the directors do a bad job, if they're not running the company appropriately, then presumably the company won't be as profitable. So the amount of profit available for dividends will be smaller than it otherwise would be. And so therefore shareholders are really bearing that ultimate long-term risk. If management don't do a good job, there won't be enough profit to pay dividends and shareholders will lose. But of course, over the last 20 or 30 years, real questions have been asked about whether shareholders really are the bearers of the residual risk. Are they really the last step in the payment priority waterfall? What about employees? So when a company gets into financial distress, it starts laying off workers. Workers are not able very easily to diversify their human-specific capital. Yes, you can work for multiple companies, and particularly these days with the gig economy, it's common for people to have multiple jobs, but it's hard to fully diversify your human-specific capital. Whereas if you're an equity investor, even a small investor, you can relatively easy and relatively cheaply, through things like exchange traded funds, diversify the risk that you have for owning shares. So are shareholders really the last stop in the payment priority waterfall? Are there other stakeholders who we might say bear some form of long-term risk in their interactions with the company? And this idea that shareholders bear the ultimate risk in the company is then used as the theoretical justification for the law to confer certain rights on shareholders. So it's only shareholders who get to vote for or against company directors, not creditors, not employees, not customers. So if we question whether shareholders really are the bearers of residual risk, should we therefore question the hierarchy in our corporate governance rules? Should we open up votes for or against directors to other stakeholders? That's something for you to think about. And really, what is the role of the law here? Is it just to fill gaps in that contracting process between the owners of capital and the managers of that capital, between the providers of the human-specific capital, between the providers of supplies to the companies, between the customers and the company? Is the law really just to fill gaps, to reduce transaction costs? Or is the law trying to substantively regulate, possibly to redistribute wealth, to address bargaining inequality between the various stakeholders, to protect vulnerable stakeholders like employees, for example? One of the things that I raise with my students in class, and normally in the first class, is to get them thinking about what is corporate law and what isn't. Because corporations are all pervasive in society, it's easy for us to look at problems in society. This group is being treated poorly, or this group has a lot of disadvantage, or there's some harmful effects going on over here in this part of society. And to look for the role of corporations, because they're everywhere. They do everything for us, just about. However, corporate law, and this is just my view, corporate law is not everything that corporations do, because corporations do everything. And corporate law is certainly not the law of everything, even if the Corporations Act is 3,000 pages long. You don't need to know all 3,000 pages in the course, mind you. So there's a balance there where we need to work out what's the problem that we're trying to address with this regulation? And is that something that actually has to be done through the lens of corporate law? Or is that, if we're dealing with environmental problems, for example, should we just have stronger environmental laws? If we're concerned about companies making hazardous products, should we just have stronger consumer protection laws, stronger personal injury laws? not everything that corporations do is within the realm of corporate law. Corporate law is largely looking internal, looking at how companies operate, how companies make decisions, what the decision-making, the authority hierarchy within the company is and how that should work. And then how companies interact with third parties, how do third parties verify that companies are actually making decisions. And this is one of the tricky things about doing corporate law, is because corporate law treats the company as if it were a real person, but a company isn't a real person. It's literally just a name on a register maintained by the Securities Commission. It's a name on a piece of paper. It's a name on a building. So corporate law is grappling with the problem of the law sets up this concept of a corporation as a real person. How does the law then implement that? How does a company sign a contract? How does a company own property or sell property? How does a company sue someone or defend against a lawsuit? These are all the issues that we look at in corporate law. Okay, so if we just focus on what is shareholder primacy. Here I've got a couple of definitions. So going back to Burley in the 1930s, directors' powers are exercisable only for the rateable benefit of all the shareholders as their interest appears. Milton Friedman, probably the most famous advocate of this view, winner of the Nobel Prize in economics. The only responsibility of corporate managers is to make as much money as possible while conforming to their basic rules of society, both those embodied in law and those embodied in ethical custom. The last bit of that quote often gets missed out. Often he's just quoted as saying, the only duty of company managers is to make as much money as possible. That's not what he said. That's the exact quote that I've got there, while conforming to the basic rules of society. So again, we come back to this question of what should directors' duties be doing? How should they work? How should they influence, cajole, punish, incentivize the conduct of corporate boards? And this is such a topical issue right now during the virus, where we're seeing banks, for example, then taking over and saying, well, we're not going to enforce home mortgages, for example. If we were really operating in a shareholder primacy view, that would be against the law, unless the government changed the law, changed the statute to require banks to do that. Of course, the bank bosses would say they're still acting in the long-term interests of shareholders, because if they support their customers who have home loans and business loans now through this extraordinary period of the COVID, then that's hopefully going to lead to a more sustainable economy at the other end of this pandemic. Whereas if they strictly enforce their legal rights, if they put, you know, a third of their mortgage holders into insolvency, the flow-on effects would be catastrophic. And that, of course, would then have negative effects on the company's profits, negative effects on returns to shareholders by way of dividend distributions. So the law allows managers and their directors to exercise a lot of discretion as to how they use the company's assets. Of course, there are rules relating to things like fiduciary duties and not misusing corporate property for their own private benefit. But when we're thinking about the decisions of boards to manage their companies in a way that perhaps is going to provide a short-term disadvantage to their shareholders, for example, by banks saying, well, look, this year we're not going to pay a dividend. We could, we're still making billions of dollars, but we're deciding that it's better in the longer term interests of the company and all of its stakeholders if we preserve that cash that we've generated, the surplus cash, and then we use that to, you know, keep branches open and to provide some support for some of our loan holders, rather than paying the same rate of dividends. So this is a very topical issue right now. Now, I've just got a few, you know, headlines from different newspapers. Why are we looking at this issue? The third one is talking about an attempt by the stock exchange a couple of years ago to require boards to consider the company's social license. That didn't end up proceeding, but there was a lot of debate about corporate social responsibility and the role of boards back in 2018. There's a quote from the Royal Commission. I've got another one on a slide in a moment. And this is one just from the Australian Financial Review yesterday, where I think this person's a fund manager Shareholders, join the back of the queue. Whatever your views on the theory of shareholder primacy, governance lesson of the last year was that the practice of running large companies has shifted to stakeholder primacy. So we're no longer just talking about how much profit can we make and how do we increase dividends for shareholders? How do we increase the value of our publicly traded securities? We're focused more on how companies are relating to stakeholders. And again, during this current pandemic, probably now more than ever, companies are taking a voluntary financial hit, sometimes involuntary, to not pay dividends to shareholders or to pay lower dividends to shareholders while supporting employees, supporting customers, not necessarily closing down all the stores or all the factories, although we still have seen some major businesses go into insolvency, and no doubt we will continue to see that over the next couple of years as the fallout from the pandemic fully presents itself. Right, so I just wanted to make the point that even though we've been having this debate in corporate law for at least the last 100 years, this is still very much topical. Boards, I know in Australia of large public companies, are very focused on this question. Are they able to manage the company's assets in a way that's going to protect jobs, even if it means the profits are lower, even if it means dividends are lower? Is that legal? That's the question. Hopefully by the end of this, you'll agree the answer to that is clearly yes. They can do that. It's not illegal for them to manage the company's affairs by considering different stakeholders. Right, here's a quote from the Royal Commission, published last year. I won't read out the whole thing. Financial returns to shareholders or providing value to shareholders, it's always an important consideration, but it's not the only matter to be considered. The best interest of the corporation can't be determined by reference only to the current or most recent accounting period, or indeed only to the current shareholders. Because in large public companies, the people who are the shareholders now might be very different to the people who are shareholders tomorrow or in 6 months. All right, so that's kind of the background, the context. Where does the law fit into this? What does the law say about what directors have to do, what they can't do? Directors and senior executives who are called officers under the Corporations Act, so the CEO, Chief Financial Officer, Chief Operating Officer, General Counsel, they would be officers under the Act. Directors and other officers have a variety of legal duties, and this is a major focus for the Corporations Law compulsory subject in the JD. And this is, for people who want to work as lawyers, advising businesses, this is one of the main things that they advise on. How can we run this business in a way that won't breach our duties, that will comply with our legal obligations? The main point for us to understand at the moment is that directors and other officers have a variety of duties, and those duties arise from different sources. One source is under the Corporations Act. So there is a statutory duty, and I've got the provision just here. Director or other officer of a corporation must exercise their powers and discharge their duties in good faith in the best interests of the corporation. So note there, it's not saying in the best interests of the shareholders. And it's certainly not saying to promote the economic return to shareholders. It's in the best interests of the corporation. Now that is a statutory version of an identical duty that arises under an area of law called equity. Directors are fiduciaries, and you might have heard of fiduciaries, particularly in the investment context, just like trustees are fiduciaries. And so under equity law, directors have a duty to act in good faith in the best interests of the company. So we have an equitable duty and we have a statutory duty, and the content is basically the same. The remedies are slightly different, and the mechanisms for enforcing those duties are also different. But for present purposes, we don't need to worry about that. Now, in the full corporations law subject, we spend a whole class looking at who gets to enforce corporate law. What role does shareholders play? What role does the company play? What role do creditors play? What role does the Securities Commission play? So we talk about that in the full subject. For today's discussion, we don't need to worry too much about it. So we've got the duty to act in good faith or to act honestly is another way to frame that, in the best interests of the company. So the key focus here is, well, what are the best interests of the company? Does that just mean the interests of shareholders collectively, or does it mean something other than that? So that's what we're going to focus on. All right, so a couple of cases. These are really classic cases that every corporate lawyer would know, that are taught in every corporate law subject. So the key principle from Rees, Smith and Fawcett is that directors must exercise their discretion bona fide, that is in good faith or honestly, in what they consider, not what a court may consider, is in the interest of the company, and not for any collateral purpose, that is not for any other purpose, such as giving themselves a benefit. So who determines what the best interests of the company are? The directors. It's very clear from the Court of Appeal in Rees, Smith and Fawcett. And this principle has been applied many times in Australian courts. This is a foundation principle of both English and Australian company law. In the High Court's decision, the CLR, High Court of Australia, decision in Metro Life Assurance and Uri, directors' discretionary powers must be exercised bona fide in what they believed to be the interests of the company. Now, this point up here from Smith and Fawcett that talks about, and not for any collateral purpose, that's a bit of a safety net, because what directors can't do is say, well, look, I think that paying myself $100 million a year in salary is in the best interest of the company because I'm the best manager in the world. Okay, clearly that would be a conflict of interest. And what we're talking about today is not focused on how we manage conflicts of interest, and conflicts are everywhere. That's a whole other topic, and we do several lectures in the corporations subject that are focused on how we manage conflicts of interest that arise with company directors and executives. So the law is saying it's not for the court to determine what the best interests of the company are, because that's a commercial decision. It's up to the directors to do that. But in making that determination, we think that doing this with the company's assets is in the best interest of the company. They must not exercise that power for a collateral purpose. So the only way that they can use the company's assets in exercising their management power is to benefit the company, to act in the best interest of the company. But who determines what that means? The directors determine what that means, as long as there's not some underlying conflict of interest. And that's why we see here in Hutton and West Cork Railway, bona fides, that is acting honestly, acting in good faith. Bona fides cannot be the sole test. There must be something more than that. And so what the courts tend to do is they look at all the evidence and they say, well, when we ask the directors, why did you do this? Why did you transfer this asset? Why did you pay this money? Why did you take out this loan? Whatever it may be. The directors, of course, will always say, hand on heart, oh, I only did this to benefit the company. So the court will assess the weight of that evidence, what we call the veracity of the evidence. Essentially, the court will assess whether it believes what the directors are saying. Did they really do it for that purpose, to only benefit the company, or were they doing it for some collateral purpose? All right, again, that's something we deal with in a separate lecture in the corporation subject. Okay, so how then do we identify the interests of the company? What are the cases said about that? We know that it's up to the directors to determine what the interests of the company are, not for the court to sit there as if it were the board of directors and to make decisions for the company. The court is just assessing what the directors have done and assessing the credibility of their evidence as to why they did it. In the Greenhow case, the English Court of Appeal picked up on the treatment of this term, the interests of the company, in the earlier appellate case in England of Allen and Goldreese of West Africa, where the court talked about, well, of course, powers can only be used, corporate powers can only be used bona fide for the benefit of the company as a whole. So in the Greenhow case, which concerned the capacity of members in a members' meeting passing a resolution to change the company's constitution. So it actually wasn't about directors' duties at all, but this has become the foundation principle for assessing what the interests of the company are, and therefore what the purpose of the company is. So here in this quote, and I won't read it out to you, but here we see the court saying that the phrase bona fide for the benefit of the company as a whole means the company not as some separate commercial entity distinct from its corporators, that is, distinct from its members, distinct from its shareholders. It means the corporators as a general body. So not an individual shareholder, not even a majority shareholder, but all of the shareholders collectively. And even though this is not a case about directors' duties, this explanation of what do we mean in good faith in the best interest of the company, or bona fide for the benefit of the company, that phrase and its discussion in the Greenhow case was then applied here in Australia in the High Court in Burley and McCann. So this explanation of principle applies in Australian corporate law. Now, what I'm going to suggest to you is that we shouldn't take what the court is saying here in Greenhow as meaning literally that it's only the collective interests of the shareholders that count. After all, the section says not in the best interest of the shareholders as a whole, it says in the best interest of the corporation. So we have to follow what the law actually says. It was interpreted, at least the general law version of that, the equitable version of that, was interpreted in Greenhow's case and applied in Burley and McCann. But we need to follow what the law actually says. And what we'll see is that there are cases that go both ways. So there are some cases that say, when we're considering the conduct of directors and asking whether or not they've acted in the best interest of the company, in good faith in the best interest of the company, then we ask, well, were they acting in the best interest of all the shareholders? That's one view. And that's applying the Greenhow statement, applying Burley and McCann. But there are other cases, equally authoritative cases, even High Court cases, and we talk about these in the subject, that suggest otherwise and say, well, hang on, the law says the duty is to consider the company's interests. And while the company's interests might, in many situations, overlap with the interests of the actual shareholders, they're still distinct. They're not the same. And the duty is to act in the best interests of the company, not merely to act in the best interests of its shareholders. And so here we've got a quote, and I've got a couple of quotes on the next few slides from the Bell case. This was one of the largest pieces of litigation ever in Australia. The case out in Western Australia went for more than 20 years. The final reasons in this particular trial decision were almost 3,000 pages long. It was an enormous case involving the collapse of the Bell Group and with some involvement from Alan Bond, the 1980s entrepreneur. So in this case, one of the issues was whether the directors had complied with their duty to consider the interests of the company by entering into a restructuring arrangement with a large group of domestic and international banks who were seeking to renegotiate the terms of their loan with the company. And the court found that in entering into that restructuring arrangement, the directors had not considered the interests of the general creditors, suppliers, employees, tax office, but had only considered the interests of the banks and had therefore breached their duties because by focusing on one particular stakeholder group and not considering how their conduct would affect all stakeholders, they breached their duty. And in this particular case, the facts that fed into that analysis were that essentially this restructuring arrangement with the banks would consume all of the assets of the company and its various subsidiaries, which would then make payment of other creditors very difficult. And it was at a time when the company was basically insolvent. All right, so the interests of the shareholders and the interests of the company may be seen as correlative, not because the shareholders are the company, and yet that's what the court was saying in Greenhow, but rather because the interests of the company and the interests of the shareholders intersect. They might be similar, but they're not the same. And the duty is to the company. It's a mistake to read the phrase acting in the best interest of the company and acting in the best interest of shareholders as if they meant the same thing. To do so is to misconceive the true nature of the fiduciary relationship between a director and a company. That is, the duties are always owed to the company. They're not owed to the individual shareholders. So with this as an example, and then going back to what the statute actually says, the duty is to consider the best interest of the company. The best interest of the company may well overlap with the actual assumed interest of the shareholders, but it's not the same. It's not a duty to only act in the best interest of the shareholders. So when you hear statements in the press with shareholders complaining that they're not getting paid a dividend, and complaining that perhaps their businesses are not calling in their debtors and businesses are extending, benefits to employees and customers and the like during this pandemic, what the directors of those companies are doing is wholly within the law. The law does not require them to pay a dividend, and it doesn't require them to consider only the interests of shareholders. Shareholders are only one key stakeholder in the company, and certainly they're very important. If the directors ignore the shareholders, they run the risk that they'll get voted out at the next shareholder meeting. So they certainly need to think about the shareholders, but they don't have to think only about the shareholders. And that's my main point here. So the Greenhill test is very problematic, and we talk about this in the course. It sets up this idea of a hypothetical shareholder. It's not the actual shareholders, because we can't usually determine who those actual shareholders, what their actual interests are, because shareholders in large public companies are changing all the time. But this is so vague, and this is just my opinion on it. This is so vague that it's actually not that helpful. Because what happens when you have a company that has multiple classes of shareholders? Even if we were to think about what do we assume the shareholders want? A sustainable company, increasingly valuable over time, but also treating its customers well so that they don't leave, treating its employees well so that they stay and they're more productive, having a good relationship with major creditors like banks, having a good relationship with regulators and the government so it doesn't get more heavily regulated. Companies can have multiple classes of shares. How do we deal with that? How do we conceptualize the interests of shareholders when we have preference shareholders and ordinary shareholders? And they might want very different things. You might buy preference shares because you want that dividend. Whereas owning ordinary equity, there might be different considerations. So we can have different classes of shares that have opposing interests. So how would the concept of shareholder primacy work in that context? Now, legally, we know how it works. The High Court in Mills and Mills, Chief Justice Latham, way back in the 1950s, told us very clearly where the interests of the different classes of shareholders are in conflict, then the duty of directors is simply to treat them fairly, whatever that means. Again, giving tremendous discretion to directors as to how they actually run the business, provided that they're not acting to try and give themselves a personal interest, which of course is not permitted and is heavily regulated. Does the law explicitly recognise non-shareholder interests? Again, we have a lot of cases that recognise that. Going back to the 60s and 70s, this is a High Court of Australia case in Harlow's nominees. It's up to the directors to decide whose interests are served within consideration of the interests of the corporation. In Tech Corp, which was a Canadian case, again, the company's interests lie beyond the interests of just the company's shareholders. So both of these cases were about hostile takeovers, and the consideration in each case was about the plight of employees if the takeover succeeded. It's okay for directors to think about how a successful takeover will affect the company's employees. So do we need law reform? We keep talking about this issue. We've had parliamentary inquiries. We've had the Royal Commission. We have periodic editorials in the newspapers about this issue. So do we just need to fix the law? I've suggested to you today that the law already allows directors sufficient flexibility in order to manage the company's business in a way that takes account of the interests of various stakeholders. That shareholder primacy is not the guiding principle of law, at least in Australian corporate law. It might be different in America, for example, particularly in Delaware. But in Australian law, if directors decide that the company's best interests are served by protecting and promoting employees, and that means the company's going to be, at least in the short term, less profitable, so there'll be lower dividends for shareholders, they've done nothing wrong. They've not infringed corporate law because shareholder primacy is not a guiding principle of Australian corporate law. That's the argument that I've made. But there are other statutory ways to regulate this. In the United States and Canada, for example, they have so-called constituency statutes, where within their corporate laws, it specifically says that directors who consider the interests of different stakeholders are not breaching their duties. So they can take into account other interests. In England, the Companies Act there provides what's called the Unite and Shareholder Value model. And this is the idea that while directors are entitled to consider other interests, and in fact in section 172 are directed to consider other interests like suppliers, customers, employees, the environment, they are doing so within the context of long-term shareholder value by making the company more successful, more sustainable, more profitable in the longer term. In the recently revised ASX corporate governance principles here in Australia, we see recognition again of stakeholder values, stakeholder perspectives, stakeholder interests. Now, these are don't have the force of law. These are promulgated on the basis of a comply or explain approach. But all companies, if you read annual reports, you'll see references to valuing stakeholders, valuing employees, valuing customers, customer focus. So we have both hard and soft law that encourages and facilitates directors considering non-shareholder interests. Previous parliamentary inquiries made it clear that law reform is not needed here. Directors can take into account other interests other than shareholders. And so where this boils down to, and I'm just mindful of the time, this is the second last slide, is that the law on directors' duties is only one small part of the question of, well, why aren't companies then doing what we as a society wants? Why aren't companies treating their employees better? Why aren't companies treating their customers better? I'm suggesting to you that it's not solely the responsibility of corporate law to address that problem, if indeed it is a problem. If we're concerned about companies making dangerous products, harming the environment, not treating their workers fairly, exploiting their customers, exploiting their suppliers, I'm suggesting to you, at least in my view, that is not primarily a corporate law question. There are other laws to deal with those problems. Employment law, consumer protection law, environmental law, etc. And I'll leave you with this quote, or I'll finish on this quote because I'm still here to take questions. This is from, you might say, the godfather of corporate law, Lawrence Gower, who wrote the foundation textbook in England in the 1950s and continued writing it for several decades afterwards. Many Australian lawyers were trained on Gower's text in the 60s and 70s before there was a comprehensive Australian law, corporate law textbook. So I won't read through that quote, but I think this really sums it up. It's not just the law telling directors to do something or not do something that influences their behaviour. If they disregard non-shareholder interests, then in most situations, the company's not going to be as successful as it otherwise would be. Okay, thanks very much for your time, and I'm happy to answer questions.